A very good day to all the lecturers. My name is Ting Sen, the leader of our group, with my member who are Cha Jing Tian, Nia Sanjay, Jasmine Tan, Emilia Shuhada, and also Nor Shafika. The question of our presentation is to explain whether you agree organ harvesting should be considered as a crime against humanity and whether new laws are needed or existing laws are adequate to address the potential challenges in proving such a crime. First of all, in regard to the International Society for Human Rights, organ harvesting means that the selling and the transplanting of the organs of victims illegally. Besides that, according to the United Nations Office on Drug and Crimes, UNODC, organ harvesting means that the exploitation of organs. According to the database provided by the World Health Organization in the year of 2007, there are estimated 5 to 10% of all the organ transplants happening worldwide are taken from the black market. In simple terms, it means that most of the victims' organs were harvested without their consent as it came from the black market. For example, in the country of the People's Republic of China, the organs will be taken from the victims without their consent and will be sold illegally. After their organs have been removed by their original owner, they will die slowly. So, surgically removing an organ is a major procedure that carries significant risks. While certain organs, such as the kidneys, are often extracted from the living victims, the process entails the considerable dangers to the victim's life and damages the long-term quality of life. For instance, removal of the kidney may result in the complications such as severe pains, serious infections, adverse reactions to the medications, or lung collapse. That's all from me, and now I'll pass the floor to the next person. Thank you.
I'm Yang Sanjay and I'm going to discuss the potential challenges of organ harvesting. One of the most pressing challenges is the secretive nature of organ harvesting operations. These activities often occur in secret, making it exceptionally difficult to gather evidence. As highlighted by the United Nations Office on Drugs and Crime, victims of organ harvesting are often vulnerable individuals, such as migrants, prisoners, or impoverished populations who may lack the means to report these crimes or seek justice. This silence only adds to the complexity of proving such cases. Additionally, the transnational nature of organ harvesting complicates legal efforts. Criminal networks operate across borders, exploiting gaps in international coordination and enforcement. Jurisdictional limitations make it challenging to prosecute offenders, as evidence and criminals may span multiple countries with differing legal framework. According to WHO estimates, 5 to 10% of all organ transplants are performed using illegally sourced organs that might come from different countries. Another significant hurdle is distinguishing between consensual organ donation and coerced or forced organ removal. The Council of Europe's Convention Against Trafficking in Human Organs emphasizes that criminals often falsify documents or manipulate victims into providing consent, creating a gray area that makes it hard to prove wrongdoing in court. The lack of consistent global regulations on organ donation exacerbates this issue.
A very good day to my lecturer. My name is Nur Shafika Minta Azid, and now I'll be talking about the existing law of organ harvesting. Firstly, Malaysia has criminalized trafficking in persons, including organ harvesting, under the Anti-Trafficking in Person and Anti-Smuggling or Migrant Act 2007, called here as the Act. According to Section 2 of the Act, the definition of exploitation includes the removal of human organs. According to Section 12 of the Act, it criminalizes trafficking for exploitations. It provides for penalty of up to 15 years in prison and substantial fines. This provision is aligned with Article 3, Subsection A of the United Nations Protocol to prevent, suppress, and punish trafficking in person, as it explicitly defines trafficking to include the exploitation of individuals through forced labor, sexual exploitation, and the removal of organs. However, while the legislation is in place, challenges in enforcement persist. A relevant common law case that could be applied here is Regina and Brown. Although the case does not specifically involve organ harvesting, it touches on the concept of consent and bodily harm. In this case, the House of Lords ruled that Consent does not justify acts involving physical harm. This principle is directly relevant to organ harvesting, where consent may be coerced or manipulated, and the act remains criminal despite any purported consent. This case can guide the interpretation of Malaysia trafficking law, where consent is irrelevant when it comes to exportation to organ removal. Furthermore, Malaysia is a state party to the International Covenant on Civil and Political Rights (ICCPR), particularly Article 7, which prohibits cruel, inhuman or degrading treatment or punishment. The prohibition directly supports efforts to prevent the involuntary removal of organ, treating it as a form of inhuman and degrading treatment. However, the lack of a specialized investigative framework and inadequate victim support systems remain significant barriers to fully enforcing these protections. In the case of Yesi Jama and others in Italy, it underscored the challenges of holding state accountable for cross-border crimes, reflecting the limitation of domestic law in addressing international organ trafficking. Although this law provides a framework, their effectiveness is hampered by enforcement difficulties, signaling the need for more specific international instruments. Therefore, while existing laws are a step forward, new laws and improved enforcement mechanisms are necessary. That's all from me. Thank you for listening. Now, I will pass the floor to Emilia.
A very good day, I'll be to the lecturer. My name is Emilia Shuhada and I'll be reviewing the current rules governing organ harvesting and their effectiveness in combating the crime. My view is that I agree and contend that organ harvesting should be deemed a crime against humanity. According to Article 3 of the Universal Declaration of Human Rights, everyone has the right to life, liberty and security of person. Regarding human trafficking for organ removal in particular, all the state parties are required by Article 3 para A, Roman 1b of the Optional Protocol on the Sale of Children, child prostitution and child pornography to take steps to be sure that the transfer of organs of the child for profits is governed by criminal law. Furthermore, without the individual's voluntary consent, medical or scientific testing is forbidden by the Article 15 of the Convention against torture and other cruel, inhuman or degrading treatment or punishment, referring to the case of Petrova and Latvia. A mother with a critically ill son was left without his consent for organ transplantation. The son passed away the following day and his kidneys and spleen were taken for transplant. The applicant filed a complaint with the European Court of Human Rights alleging a violation of Article 8 Convention for the Protection of Human Rights and Fundamental Freedoms. The court held that the interference breached the applicant's right to respect for her private life under Article 8. In this case, domestic law did not explicitly specify the scope of medical practitioners' obligations or discretion. Moreover, in the case of Wang Xingqing against public prosecutor, Wang, an intermediary in 2 kidney transplant deals, was found guilty. He arranged for Indonesian donors to be accommodated and medically examined, and he charged a greater cost for the second transaction. The appeal was dismissed due to Wang being deemed to be the most accountable party, taking advantage of contributors and recipients. In summary, whether internationally or nationally, the regulations governing the crime of organ harvesting are inadequate. There is no explicit regulations governing organ harvesting, rendering the current law inefficient in deterring this unlawful act. Thus, reformation should be implemented in order to charge and convict the perpetrator for violating international human rights regulations. That's all from me. Now I shall pass the floor to the next person. Thank you.
My name is Jasmine and I'll be discussing on whether Malaysia needs new laws to address the potential challenges in improving organ harvesting. The current law in Malaysia that addresses this subject is the Anti-Trafficking in Persons and Anti-Smuggling of Migrants Act 2007. This legislation primarily aims to combat human trafficking and migrant smuggling, focusing on various forms of exploitation, including forced labor, sexual exploitation, and organ harvesting. However, the Act does not provide comprehensive or exclusive coverage, specifically targeting organ harvesting as an independent offence. Instead, it deals with human trafficking for the purpose of organ harvesting, where traffickers exploit individuals by coercing or deceiving them into having their organs removed for profit. This means that organ harvesting is treated as a subset of human trafficking rather than a standalone crime. The Act imposes severe penalties on traffickers, including imprisonment and fines, but there remains a need for more specific legal provisions to address the complexities of organ harvesting, particularly when it involves international crime syndicates. In comparison with the Council of Europe's Convention Against Trafficking in Human Organs, this convention also targets recipients who knowingly participate in illegal organ trafficking, as well as intermediaries. To combat this transnational crime, it places a strong emphasis on victim protection, preventive measures, and international collaboration. The Convention holds offenders accountable while guaranteeing that organ donations continue to be morally righteous and voluntary. It supports other global initiatives to protect human dignity and stop medical exploitation. This shows that Malaysia needs new laws to adequately address the potential challenges or make further amendments with reference to international treaties and conventions, improving the crime of organ harvesting. Efforts can be seen to address this, such as on 7 April 2023, when Malaysia has signed the Declaration of Istanbul on Organ Trafficking and Transplantorism 2008 that condemns and aims to halt transplant commercialism, organ trafficking, and transplantorism. That is all from me. Thank you.
My name is Chua Jing Tian. In addition to the earlier example, it is crucial to explore the legal frameworks established by other countries to address organ harvesting issue, as they offer important insight for developing and amending new law. China has faced several allegations of forced organ harvesting. The illegal trade and forced harvesting of human organs are violations of human rights and have drawn a global attention. China, as the second largest country for organ transplant, has taken steps to address this issue through several regulations. These regulations, issued by the State Council of China, aim at strengthens a previous ban on organ sale and ensure more standardized transplant procedures. The new measure include revoking licenses for doctors involved in illegal transplant and suspending hospitals for performing transplant for 3 years and imposing heavy fine up to 10 times the profit earned from such trade. Officials found guilty of participating in or allowing organ trafficking are also subject to dismissal. Moving on, in United States, the National Organ Transplant Act 1984 prohibits the sales and purchase of human organs and enforced penalty for trafficking. It emphasized ethical organ allocation and voluntary donations. Next, in United Kingdom, the Human Tissues Act 2004 criminalizes the removal and trafficking of organs without proper consent, imposing penalties as severe as life imprisonment. This reflects the UK's strict approach to protect human rights in organ donations. Moreover, India, the Transplantations of Human Organ and Tissues Act 1994 explicitly prohibits the commercial trade of organs and target trafficking. It also outlines ethical guidelines for organ procurements. Additionally, in Singapore, the Human Organ Transplant Act bans the sales and trafficking of organs with strict penalties for violator. Singapore also promotes a donation system to encourage ethical sourcing. Each country of these slide mentions demonstrate efforts to address organ trafficking, yet differences in enforcement, transparency, and ethical practice creates vulnerability in the global system. Despite this legal framework, several critical gaps exist that undermine global efforts to combat organ trafficking. The first gap of law is the lack of global enforcement. While countries like the US, UK, India, and Singapore have strong laws domestically, this framework failed to address cross-border transplant tourism. This allowed individuals to exploit weaker systems like in China. Moreover, there is no unified global standard for trafficking organ donations and transplant, creating inconsistency and enabling opportunities for illegal organ harvesting and trafficking. Not only that, current law lack of the mechanism for cross-border investigation, extraditions, or sanctions, limiting the ability to dismantle international organ harvesting network. To address these challenges, we humbly propose the Global Organ Trafficking Prevention and Enforcement Act, an international treaty that will establish a comprehensive legal and enforcement framework for universal ban on organ trafficking and forced organ harvesting. All member states must criminalize organ trafficking, forced organ harvesting, and transplant tourism. Moving on, there must be an international transparency and verification standards, which is a global registry must be created to track all of the organ donations and transplant. Member states must adopt uniform reporting and auditing procedure to ensure transparency. Furthermore, there must be sanctions for non-compliant states, and this sanction will target industry, entities, and officials that involved in the practice. Next, it is necessary to establish an international task force to facilitate cross-border investigation, prosecute offender, and dismantle trafficking network. That's all from me. Thank you.
In conclusion, organ harvesting presents a grave challenge to humanity that demands urgent attention. It is not just a criminal act, but also a potential crime against humanity due to its scale and impact on vulnerable populations. Existing laws require significant enhancement to address the complexity of this crime effectively. The establishment of new laws are also necessary to address the troubling issue of organ harvesting. Stricter international cooperation, clearer definitions, and stronger enforcement mechanisms are needed to ensure that justice is served and human dignity is protected. That's all from our group. Thank you.